Chauncey, and I am an advisor with the Illinois SBDC at Bill Bronzeville. And it's also facilitated by managing attorney Elizabeth L. Carter, Esquire. So the training is part of the 2020 Road to Recovery series that is brought to you at no cost thanks to the partnership of the Illinois SBDC at Bill Bronzeville and at Greater Englewood to help you stabilize and grow your business in today's climate. It's funded in part through a cooperative agreement with the US SBA, the Illinois Department of Commerce and Economic Opportunity, and the Urban Juncture Foundation, as well as the Greater Englewood CDC. And as I mentioned before, we're honored to have managing attorney Elizabeth L. Carter here to share legal expertise. Why is this important? Well, health and safety needs and shelter in place mandates change business operations. I know you guys are probably just as excited as I am about the state of Illinois opening businesses this Friday. However, part of the reason why it's important to have a virtual business is the fact that we had to shut down or shelter in place for a while. Also, current and new customers still benefit from your products and services. And online sales have been, are, and will continue to be a solid source of business revenue. Tap in the chat if you agree. Do you agree and understand that it's very important rather that you have an online business? Don't be shy. Okay, well, so we'll address 3 matters today. Okay, thank you, Sai. He says most certainly. Yes, yes. So we're going to address 3 matters today. 1, easy to access online platforms to feature your business. We'll also talk about tips to establish and maintain your online business legally, which Elizabeth will highlight. And then, there will be time for questions and answers. So what is e-commerce exactly? If you are aware of what that means, type in the chat and let me know. Raise your hand or just say yes if you're familiar with the definition of e-commerce. Okay, thank you. I'm getting some feedback. I still would like to thank you. Yes, okay. So by your responses, I see that some people know. And just so that everyone's clear, let me explain briefly. E-commerce is the buying and selling of goods and services on the internet. There are many ways for customers to become aware of or buy your goods and services, but you want to be sure that your customers can do so easily and safely. So let's review a few e-commerce platforms that you can consider for your online business. The first one, I'm sure everyone has heard of Google, right? So Google My Business is a wonderful e-commerce platform that you can consider for your business, your online business. It's a central spot where people can find you via Google search or Google Maps, which I'm sure you have had experience with that. You've typed in a business from your home address or business, and that information that tabulates as you get directions is based on the company's My Google Business platform. And what's nice, again, is that it's pretty simple to use. You can simply update your Google profile and you can add information such as service changes or your hours. So let me take a step back. Let's take a look at the site exactly so you can see what I mean. All right, so in this case, you see that you can simply set up your website here. You're able to type in your business information, and we'll get into that in a little bit more detail in a second. But let me take you through just a brief overview of how Google My Business works, right? So in this example, you can see Chicago Music Exchange is the business that is highlighted, right? They have their address and Also, one can call them, get directions, or message them, or the website. Like I said, we'll go over that in more detail in a bit. And again, it's simple to set up. And so once you've set up your Google My Business profile, you could have specials like this in this example. The acoustic guitars are 20% off, right? And you click here to get the offer. And it gives you opportunities for your customers to reach out to you, right? You can do messaging. And just to give you an overview of what it looks like as far as why it's important to be or have your Google My Business profile. Well, look at the numbers here. Every month, there are 5 billion searches for restaurants. Type in the chat and let me know if you have a restaurant. Do we have some restaurant owners with us today? Also, there are, maybe do we have boutique owners? 1 billion searches for clothing stores. It's amazing. And then are there any hairstylists here online with us? 600 million searches alone for hair and beauty salons. And then maybe you're a coffee shop owner. There are 5 million searches. But what I want to highlight here is the importance of you having your business on Google so that people can access you just by a simple search, even if they're not already aware of you. Does that sound good to you guys? Type in the chat and let me know you're still with me. You want to stay engaged? All right. I know maybe you're being a little shy. That's all right. So we'll keep going. Another e-commerce platform that you can consider is to use Instagram for posts, stories, and shopping. The thing about the posts is that you could easily just upload an image and then have a brief caption about it, and they remain until you delete them, versus stories that are seen for 24 hours before auto removal, unless you highlight them in your reel. And then there's Instagram shopping. How many of you are familiar with Instagram shopping? We're gonna go over that now in a little more detail. You can type in the chat to let me know if you are already familiar with that, but we'll take a look. No, okay, so great. As you can see, Instagram gives you a checklist for opening the storefront, and they ask you step-by-step questions so that you can go through this in the process in 5 steps. The first is to make sure you're eligible, for Instagram shopping. And you see a number of the questions that are listed here, like, do you have an Instagram business account? Does it comply with commerce policies, which Elizabeth's going to address in a bit? Secondly, you can connect to a catalog, like Catalog Manager or Facebook Partner. The third step, and before we get there, let me just show you an example of shopping. If you're not already aware of Instagram shopping, this is an example of what you could have. You know, in this case, we have the vegan leather wristlet and the price for it, and one can click on this to learn more about it and to make the purchase. And you see in the third step, you sign up in the app. The fourth step, you create your first shopping post or story. And then of course you want to be able to get insights. That's step 5, right? You can use the insights tab in Instagram to find out how your posts and stories are performing. And I see, yes, we have a question about whether or not it's free to open an Instagram account. Yes, it is. And let me say that you're welcome to ask questions, and you can add them in the chat, but we'll also have time, as I mentioned in the beginning, to discuss questions and answers before we wrap up. So that's just and then there's some FAQs here. So take a look at that for more insight at your convenience. Click, if you would, in the chat, tell me, do you use Instagram shopping, or can you see yourself using it given your business? Don't everyone reply at once. Can you see yourself potentially using Instagram shopping? Okay, perhaps. All right. All right. So the third e-commerce platform that I like to share and offer that you guys consider is to sell on websites. You have websites like Shopify, which is known for being best all around, Wix, great value for the price, and Squarespace with its best design templates. So let's take a look at each of them, briefly, just so you can get an idea of what they look like. So here we have Shopify, right? And it says build an online business no matter what business you're in. I'm sure you guys have a variety of businesses online, or you're looking to develop them. So again, consider taking a look at this. As you can see, Shopify offers an extended 90-day free trial. So that may be ideal for you. And as you see here, Nate, you said you're not sure how it can benefit a service business. Well, take a look at this. Here's some examples where, well, okay, they don't have service businesses, but we could talk to you. We'll talk to you in a bit about how you can work with us one-on-one to get some clarity on that. But just for quick examples, you see that Shopify has, you can highlight food and drinks, jewelry, or beauty and cosmetics, just to name a few examples. Now let's take a look at Wix for its great value for its price. And they tell you right away, right? There are different highlights, and you could take a look at how to set up your web presence. Because of the time, we won't be able to go through everything, but you see that there's some examples here, and the fact that you can customize your site, which is important. Maybe you need to add a blog, and so forth. So, and then SEO, we're not going to talk about SEO today, but search engine optimization is very important too when it comes to your website. And then lastly, as I mentioned, another e-commerce platform you may want to consider is to sell your services or items on Squarespace. Squarespace is known for its best design templates. We could take a look here. It even is started. Is your business in education? Is it personal? Is it interior design and marketing and consulting, just to name a few? And then if you don't see it, there's a space to describe what your site is about and potentially giving you additional ideas as to what you may want to highlight and what kind of template you want for your business. Has anyone used any of the websites that I've mentioned to sell your products or services yet? Or can you see yourself being able to do so? You could type in the chat to let me know. Oh, Wix, okay. One person says Wix, all right. Anyone else? Okay, have not, but will use. Thank you so much. We want to keep this engaging, and I appreciate your feedback. We appreciate your feedback. So even if you haven't, great, yes, excellent. Okay, we got people who like Google Business and people who are open to it, haven't used any of the platforms yet. Beautiful. Okay, thank you so much for your responses. It makes all the difference. And so one last note about e-commerce general safety. You want to make sure that your website has the HTTPS. That S determines or shows that it's secure. In the example I have here, right, is the HTTPS zoom.us. And what that shows is that you can send sensitive information over that connection, and it makes your shopping or online banking, for example, secure. It also protects you with normal web browsing while you're searching. So that's really important to keep in mind. So again, I appreciate your attention. And now it's my honor to have Managing Attorney Elizabeth L. Carter speak with us about how you can be legally compliant with your online business.
Thank you, Rebecca, and thank you to all of the partners for including my firm as a presenter on such a very important topic for our businesses. As mentioned, we have seen an increase in e-commerce since COVID, and it is important that our small businesses have foundational knowledge of some of the legal implications of their online activities. I'm happy to share this knowledge, but also must inform listeners that this portion of the presentation is for educational purposes only and does not serve as legal advice. So e-commerce laws are very, very broad and include laws surrounding topics such as data privacy, consumer protection, digital copyrights, e-signatures, e-contracts, and terms of use. This is not an exhaustive list, but it will provide a great start to your foundational knowledge of e-commerce. E-commerce laws vary by state to state and even by country to country. As such, a small business owner should have appropriate legal protections in place in order to ensure compliance with each applicable state and or country, and that will be sufficient in preventing liability, which can include significant monetary damages and forced shutdowns of the website and or the business itself. What makes matters even messier is that e-commerce law is still unclear and is constantly being changed due to the novelty of the internet. For an example, there's still debate on whether a signature line in the email satisfies the signature requirement for an executed contract, or whether an email is considered a writing at all under general contract principles. Thus, it is best to hire an attorney to help you understand which laws, if any, are applicable to your online business. So let's get started with the Illinois Data Transparency and Privacy Act. So this act, well, I assume that most of our listeners live in the state of Illinois, so it makes sense that we speak on this particular legislation that is currently being proposed within the state legislature. Although not law yet, it is likely to become law soon, especially in light of the increase in e-commerce, as we mentioned. So what does this law mean? So the law applies to Illinois businesses that collect and sell personal information from at least 50,000 Illinois consumers, where at least 50% of its annual revenues are from the selling of consumer personal information to third parties. So this means that if you have a website that collects personal information from a consumer, in other words, collecting names, addresses, credit card info, social security numbers, and even the storage of cookies, such as purchase histories, etc., and you sell this information to third parties, where the revenue from these sales amounts to at least 50% of your overall annual revenues, then this law will apply to your business. So you can imagine this is especially applicable to major website owners like Facebook, LinkedIn, Instagram, which sells your personal information in order to provide quote unquote free access to your services. So, or their services. So I know there was a question earlier about whether Instagram, signing up for Instagram was free. Technically, yes, but nothing in this country is free. So what you're selling in return is actually, you're giving Instagram the ability to sell your personal information, which there's a whole market for personal information. I don't know about you all, but I receive, constant scam likely, calls or what they call collectors and people who want to sell you things. This is because your information has been put out into the world, in this case, into the dark web, through the selling of information, of which, as I mentioned, websites like Facebook and LinkedIn have done in order to then give you free access, quote unquote, free access to their services. So what exactly does this law require the small business owner to do? Well, this particular Illinois law, it establishes a number of consumer rights that the business owner has to abide by. And just quickly, these rights include right to transparency, and we'll normally see that through, basically, you need to have a privacy policy on your page. You need to, the consumer has the right to know what type of information is collected and from what source. The consumer has the right to opt out from the disclosure and selling of their personal information. The consumer has the right to correct misinformation or errors that the business owner or the small business owner may have about them. And the consumer has the right to request the business owner to delete their personal information and to require their third parties to also delete the information. However, if the information is necessary to maintain a business relationship with the consumer, then the business does not have to take that down, unless of course the consumer no longer wants the business relationship, right? So in other words, you cancel or delete your Instagram account, Facebook account, or in your case, as a small business owner, you may have memberships or you may have users that engage on your website. And again, because of COVID, I foresee that a lot of businesses are going to start having much more engagement on their websites. Normally you'll see just like an advertisement sort of space for websites, but moving forward, people are going to have much more, opportunities for purchasing items and services, and also feedback, which include a membership chat. And so even with that, that involves a business relationship between you and that consumer. And if the consumer no longer wants that because of whatever reason, then you have to remove and destroy their information, no longer sell it, right? This law also has set parameters for the procedure for requests. So basically, a business must also have a procedure for responding to a consumer request. So if a consumer wants to have their information deleted, the business must have a link somewhere on their website, or like a contact button, or somewhere where the consumer can contact the business owner and say, hey, I want you to remove me from your membership base or your service. As well as the business owner should have a procedure for risk assessments. So basically, you as a small business owner should conduct an assessment of your processing information activities in order to stay relevant, and also to stay compliant with different changes to your procedure, and also you can stay relevant to the disclosure requirements. So essentially, at the end of the day, what this basically is saying that you establish a privacy policy, which will describe how you collect information, disclose information, and use consumer information, as well as what type of information you are collecting and from which sources on that consumer. And a business owner cannot use a consumer personal information for any purpose other than those disclosed in the notice at collection. And I think it's important to note, as I mentioned earlier in the introduction, that e-commerce is a very broad form of law. It crosses states, it crosses countries. So every state will likely have their own sort of data transparency and privacy act. Some states do not necessarily have it per se, but others will. And you have to make sure that if you're receiving a significant amount of users or consumers are coming from these other states, that your policy adheres to those states as well. So it can get complicated. Like say, for instance, you have 50-50, Illinois, Indiana, 50-50, and Illinois and Indiana has their own privacy act. You need to make sure that your privacy policy adheres to both at least, right? As well as for other countries. Now, the European Union, the United States engage in an agreement whereby so long as if you include certain safe harbor provisions in your privacy policy, and you also derive a lot of your business from European Union, then you should be safe in terms of how you're using your information. So yeah, again, you just got to make sure your privacy policies are compliant with all these laws, are tight, and not just sort of boilerplate. A lot of people use boilerplate, say, oh, I can use this, and not really understanding whether it applies to their particular business or their particular state. So we can go on to the next slide. Again, as I mentioned, the e-commerce is a broad form of law. It includes laws of consumer protection. E-commerce includes consumer protection laws, both at the state and federal level. So here we have the Illinois Fraud and Deceptive Business Practices Act. And many states will have their own versions of consumer fraud acts, as well as the federal government does have its own. We'll discuss that later. So really, this is simple enough, I should say. For an example, this act applies to the representations you make in your privacy policy, right? So if you state in your policy your procedures for collecting information, and you do not actually engage in those stated procedures, then you can be liable for fraud under this consumer protection law. So therefore, again, you must make sure that you actually do what you say you do in your policy. So not only is it that you need to have a policy in regards to how you collect and dispose of data from consumers or your users, you must also make sure that what you state is up to date and is actually true. So it's very important that you have a policy for updating your policies on a regular basis to make sure that you could be compliant with one law, in other words, a privacy policy, but non-compliant with the consumer protection if a consumer feels that they were misrepresented, or they can accuse you of fraud, if they find out that you were doing something else with their information than what you stated. So it's important that you comply with all these different laws. The next slide, as stated, it's the Federal Trade Commissions Act, which again is just the federal version of the same state law, which we just went over, the Illinois Fraud and Deceptive Business Practices Act. This is the state or the federal version, and it's the same thing. Federal law, usually when there's a state and federal law, so long as the state law doesn't conflict, both laws can be applicable to your business. And this is where the consumer would just have a choice as far as claims. They wanted to pursue a lawsuit, they'll either choose the federal or the state law, depending on which law is more favorable to them. And I think the reason why I wanted to include this in the slide, I just think it's important to highlight the multi-jurisdictional / nationwide, even global wide implications of e-commerce law. So you're not just under other laws, for instance, criminal law. You're just really bounded by, for the most part, unless you're crossing state lines, the state law, or even real estate, right? You're really just bounded by that particular state law regarding real estate. But with e-commerce, because you're just not engaging in brick and mortar business, you're saying you open your business to the world wide web, you're literally being regulated by all these different versions of law. And as I mentioned about the European Union, I mean, obviously, again, these laws are constantly changing and trying to be more practical. So even with that, there's going to be agreements where it makes it easier for the business owner to engage in business, because they understand that all these conflicting laws will just make it impossible to abide by. But for the most part, they're being much more refined. And so in this case, the federal law still applies to you, your particular state law applies to you, and if you engage in any other business, maybe like I say, your consumers deriving significantly from another state, that law also will apply to you. So again, it's important that your policies, your terms and conditions, etc., whatever you put on your website is comport and apply and adheres to these different laws. So we move on to the next area of law. Again, like I said, e-commerce is very broad. So another area of law, or another aspect of e-commerce, is the U.S. Digital Millennium Copyright Act, which specifically protects copyrighted material that is posted and or hosted on a website. So just for background, the U.S. Copyright Act of 1976, which I think more people are familiar with, protects all original works of authorship, whether it's online or not, including artwork, literature, music, film, etc. Any unauthorized use of these works is called an infringement. An infringement upon someone's copyright can result in both civil and criminal penalties, except where there's a defense, such as fair use defense, which includes educational purposes. So the U.S. Digital Millennium Copyright Act essentially creates 4 additional defenses to copyright infringement, specifically for online service providers. And this is because of the nature of the internet, right? And because that the website owner is not necessarily in control of what its users or its members are posting on its website. So they're trying to provide some safe harbor provisions or protections to that website owner for acts by third parties or end users, what they call them, right? So these include transitory communications, system caching, storage of information, and information location tools. So again, these are safe harbor protection or defenses of which a website owner can use so that it itself is not liable for a third party, i.e. its end user or acts of its end user. Transitory communication essentially is an internet or telephone service provider. So it wouldn't really apply to anyone on this call for the most part. This is just those who provide internet service, and there's information that transmits through these lines of communication. And you want to make sure that those particular lines aren't modifying or affecting the transmission of that particular material. But what will apply to most people on this call, the last 3. System caching is basically where a website owner temporarily stores digital material that is frequently posted on its website by its users for purposes of making such info available to other users without having to go to the original source. So it's really creating a copy of the original material. So for an example, an Instagram user screenshots a photo from another user's profile and posted it on his own profile page. But before that reposting occurs, Instagram has a system in place that automatically transmits that copied photo to the other user's page. So what happens when Instagram user 1 does not have permission to screenshot and repost the image to his page? Well, it becomes copyright infringement. Under the Digital Millennium Act, Instagram will have to ensure the following requirements before it can use the system cache defense against the third-party copyright infringement. So in other words, Instagram has to automatically store, automatically is important, and transmit digital material upon the direction of the end user. So in other words, when the user posts it, it's not that Instagram itself is posting anything, it's an end user that's posting the material, which is very important. Because if Instagram is actually doing the posting, neither of these defenses will apply for Instagram. It will have to find another defense under the original Copyright Act. Another requirement is that Instagram must have a repeat infringer policy, which basically states what happens when a user engages in copyright infringement. It needs to have a policy so that the users are aware of its activities and what will be allowed and not allowed. Instagram must also make contact information available on its website and provide this contact information to the Copyright Office so that copyright owners can provide notice of the infringement to the website owner, i.e. Instagram in this case. So if there's an infringement, they must be able to contact Instagram and say, hey, one of your users are infringing upon my rights. You need to take it down or block access, which I will get to in a minute. In addition to that, Instagram must also not have knowledge or participate in this act of infringement. Again, this Millennium Copyright Act covers third-party infringement. It does not cover infringement by the website owner itself. That will have to, they have to use defenses under the original Copyright Act. And so once Instagram is made aware of the infringement, so when the copyright owner, utilizes its contact or finds its contact information, provides sufficient notice of the copyright infringement, and it's sufficient enough, and there's legal rules as to what that notice should look like, and Instagram says, okay, we agree that this was infringement, and mind you, they don't have to agree or not, but it's just the notice have to be sufficient. But Instagram must then take down or block access to the infringing material once it has been notified by the copyright owner. And this is the same for storage information and information location tools, but I'll just go into what these are. So the storage information is where a website owner actually store unique or specific information pertaining to a particular user that is not frequently used, uploaded. So for example, this includes websites that provide mailing lists, chats, and photo video uploading capabilities. And for a further example, this is, for instance, a YouTube user uploads a personal video that they record on their phone to YouTube. And then YouTube then stores these personal videos on its own server for that user's personal use. So in order for YouTube to take advantage of this storage of information, copyright infringement defense, it has to abide by certain legal requirements. So those that I just already mentioned, in addition to not having the ability to control the infringing material or receive financial benefit from the material. And lastly, the information location tools is just where it's a website owner that provides online search engine facilities on its websites, including hyperlinks, directories, and other reference links to infringing material. So this is where a website owner has, for instance, many of us have hyperlinks on our website where people can click on and it takes them to another page or external page or internal page, but it takes them to a new location. And if that link takes the user to a place that has copyright or infringed material, then that website owner can be liable for that infringement material if it doesn't abide by those requirements that I stated before. So in other words, just have a repeater infringer policy in place, take it down when it's being requested, don't have any, didn't do it itself. Like in other words, it's not it. YouTube or website owner did not post a link itself. It must be because of your users did it. And so I think it's important to note that this act only applies to conduct by end users and not by the website owner itself. If the website owner itself posted links or other infringed materials, such as a photo that was owned by someone without permission, then the website owner cannot claim either one of these safe harbor defenses. It will have to, again, defend itself under the U.S. Copyright Act of 1976 and maybe argue that it was for fair use, educational purposes, right? That's just one way to defend itself. So that's the U.S. Copyright Act, again, in response to, obviously, it passed in 1998, in response to the increase in internet use of the World Wide Web, and it's still being changed and still being forever amended so that it makes things practical for today's environment. And so we can move on to another, huge topic under commerce law. So far there, as we see, there are a number of laws that apply to e-commerce. Another one includes the law surrounding electronic signatures. So the electronic signatures in global and national commerce provides validity and legal effect to digital signatures. Also, the Uniform Electronic Transactions Act, which Illinois has adopted its own version, eliminates the requirement of a written signature for the sale of goods and services via e-commerce. So, for an example, as we know, I do a lot of transactions virtually as well. If I have a digital signature, I put it on my documents to validate the contract, to let the other side know that I agreed to the terms, and then I send it. I can't later then argue that that's not my signature, right? Unless, of course, someone else used my electronic signature and I have to go through the process of proving that. But for the most part, what this is saying is that e-signature is just as valid as your handwritten signature. The Uniform Electronic Transactions Act is similar in that what it says is that, okay, so there's what we call the UCC, or the Uniform Commercial Contract Law. And under this law, for instance, it requires the purchase of an item priced $500 or more to have attached to that purchase a written signed contract. So the seller can't just sell an item of that value or more without a signed written contract. And if it does, then it doesn't really have a defense to if there's a dispute, right? And so that seller want to make sure that it's protected by having a contract saying, okay, I sold you this refrigerator for $1,000. You signed your name on it. It's yours, and it may have warranties, et cetera. So that's a whole different issue. But for the most part, what it's saying is if it's worth a certain amount, it needs to be signed and written. However, under this Uniform Electronic Transaction Act, it eliminates that sort of common law requirement for old ways of doing things, to acknowledge the fact that people are buying things online now, not just in person, so that it eliminates a written contract period. So you'll have a shopping cart like Shopify, you'll click the button and say, I want that, and it's priced at $501. You don't have to necessarily sign a contract with your name on it. It's yours, and then the transaction will be recorded, and that's a valid transaction that can be defended at law. And so we go on to terms and conditions. Since that relates to contracts, this is an electronic contract itself. It is not a policy, for instance, of like a privacy policy, which has its own laws and requires it in some cases. Here, this is a pure optional contract that the website owner wants to put on his website so that its users understand what they're getting themselves into and what they agree to. But it's very important to have it, even though it's optional, because then there's record of what the website owner allows and don't allow, so that if there's any issues such as copyright infringement, if there's any issues of warranties, or maybe you have return policies, you put explicitly in this online contract called the terms and conditions, so that the user does not then come back to you and say, oh, I didn't know, or I didn't agree. But I will say this, the main concern regarding these terms and conditions is the enforceability. So even though you have a terms and condition, you want to make sure that it's not just boilerplate, because you don't know where that boilerplate language came from, whether it really applies to your particular business, or whether the language in there is enforceable. I mean, there's unconscionable terms, there's terms that are against public policy that the courts will not uphold. And so you want to make sure that you have a particular terms and conditions that is enforceable, that does apply to your particular business in your particular state or states that where you do business. So for instance, requiring users to read your terms and click agree, right? We've all had that situation where you go through it before you sign up, like for instance with Instagram or Facebook, before you sign up, it'll have at the bottom in small words, smaller than the words on the website, that says, read our terms and privacy policy before you sign up. And when you read it, you click sign up, and they assume that you agree to it because you click sign up. And this is regardless whether you actually read the terms and conditions or not. The courts have held that you agree to the terms, even if you did not actually read the terms, so long as you were able to, or the user was able to, was provided reasonable and adequate notice that they were agreeing to a contract. And so you want to make sure the website owner that language, your terms and conditions, is posted on your website very clearly, conspicuously, and not ambiguous, right? Because then the user can come back and say, well, even though they had it there, I still, it was too small for me to read. It included language that didn't, was ambiguous to what I was really agreeing to. It was not clear. You can have problems with enforcing your terms and conditions. So what happens when because we see this a lot, when there's a terms and conditions listed at the bottom of a website that just says terms and conditions. So unlike the former example where, before you even can sign up, there's a blast that says sign up and read our terms before you do. That is more, have been held by courts to be has shown to show that you actually agree, because it's an affirmative thing that has happened, right? Something popped up, it gave you an opportunity to read before you sign off on it. But when it's simply posted, you may not even notice it at all. You may just be going through the website and never notice these small words at the bottom of the website. So what the courts have shown is that when it's merely just posted, you should still have some type of procedure that requires the user to affirmatively agree to the term, such as through a click of a button, as I mentioned, or where maybe you send a blast email once they sign up for your mailing list or something like that to say, hey, before you continue, we want to make sure that you agree to these terms, and we will give you access to the website and to all the sort of goodies that comes with it. And this can be done, or it can be done even through some websites now, or websites host providers have an option for the website owner to have like a pop-up on their website, and you can include even in there maybe an language that says, before you continue on, we want to make sure that you agree to the terms. This is the same thing if it was something of adult nature and they want to make sure you're of age, they'll have something that pops up that you click and confirm that you're 18 or older. So something similar like that. So be clear, courts will rule terms unenforceable when it's so one-sided as to amount to be unconscionable or against public policy, or that include consumer fraud issues such as unfair trade practices, right? So again, it just makes sense for you to consult with an attorney to make sure that your actual language is enforceable, is applicable to your particular state or your particular consumers, and not just some boilerplate that has nothing to do with what you're doing or maybe against public policy. And it's the same thing if you're amending your terms and conditions, constantly, providing notice of amendments, letting users know that things are changing so that people cannot argue against you and say that they weren't aware of these new terms. And this is where they will try to, depending on what it is, and if they feel harm, they can file a lawsuit against you. And that can really damage your business, especially as a small business owner. You don't have the legal wherewithal or the legal army to kind of, constantly battle these 50, 60, 70,000 users that's on your site. And so again, reiterating, you shouldn't have a boilerplate TOC or terms and conditions. It should be legally binding, just as any other contract. And it's important to have an attorney review or draft your terms and conditions so that they ensure enforceability. And that is all for the most part. Like I said, e-commerce laws, this is not even to have. There's so many other electronic statutes, et cetera, that applies to e-commerce. But I believe that these are some of the bulk of it, and it provides you with enough foundational knowledge for you to start to really get your online business going and feel comfortable with going. But again, I advise or suggest that you contact a lawyer to kind of have like a legal analysis of what your online virtual presence look like, to make sure that you're abiding by the laws. Because again, you want to do business. You're not here to just you're not in business getting sued, right? You're in the business of actually selling goods and products that are quality for your users and or site viewers. And that's all for me.
All right, everyone. Thank you so much, Elizabeth, for sharing your legal wisdom and insight with us so we can remain legally compliant with our virtual businesses. Are there any questions or comments about what information you plan to implement today? Please type them in the chat. Oh, thank you. Thank you. Aston, I see we appreciate your response. And thank you to everyone for your participation and for the gifts you share with Chicago communities through your business or in businesses in Illinois. I should not just say Chicago. We may have some people that have businesses outside of Chicago. But are there any questions about what has been shared already or feedback? Please share in the chat. Okay, I think everyone seems to be in a good place. Oh, okay. So Aston has a question. Do these websites have merchant services built in terms and conditions? Clarify for me, Aston, these websites, are you referring to Spotify, Wix, and um, my apologies, and the last one that I shared? Are you talking about those the websites that I was saying you may consider? Okay, the three that I spoke of. So that is a good question. And I will have to research that for you, and I will certainly get back to you. I know how to get in contact with you. Are there any other questions? You're welcome. You're welcome. Any other questions? And thank you for your understanding. All right. So contact us for appointments. You know, we only, as Elizabeth mentioned, we touch the tip of the iceberg with e-commerce legal insight, as well as potential ways that the websites that you may consider, or the ways in which you can set up your e-commerce business. So call us or email us or visit us. If you are near Bronzeville or in the Bronzeville area, you can reach out to us at the Illinois SBDC at Bill Bronzeville. And for those of you that are in in Inglewood, reach out to our partners at the Illinois SBDC at Greater Inglewood, email, website, and calling. And then, of course, Elizabeth Carter, managing attorney, you can contact her in these ways: email, website, as well as a phone call. And Elizabeth, did you want to add one more point?
Yeah, I would like to say that, you know, and because I know this was a lot of information and it's very in depth, but if you have any questions, you can feel free to contact me. We can schedule a consultation. If you have any particular questions about your own sort of data or privacy policies, terms and conditions, and or repeat infringement policies. And then I did see that someone sent me a question about how to prevent hackers. What I will say to that question is that oftentimes in these privacy policies, you should have sort of procedure on what happens if there is a sort of a breach, right? A data breach. And those are more cybersecurity questions, but it is related to privacy policies, in that it should include information as if it was, you know, your information was erroneously disclosed or unauthorized disclosed. And so they should have that in there. But there's other things like spyware, software programs, and different domains will have their own protections against sort of disclosure of public information. So there's, like I said, this type of area law is very in depth, and it includes so many different angles. So feel free to contact me if you have specific questions, and then I'll see if I can answer them. And then also, like I said, we can schedule an official consultation. But namely, if you have any needs for your own policies or terms and conditions, I can definitely help you with that as well. And you probably shouldn't, and I think someone asked if those websites had like terms and conditions built in. Going back to my main point, even if they did, I think they probably have some providers that do. You still want to make sure it's compliant for your particular business, your particular states that you're in, and that you're doing a lot of business out of. You don't just want a boilerplate. Just kind of put that out there as well. So thank you, and thank you for having me. This is great.
Yeah. Thank you, Elizabeth. We so appreciate it. And oh, wow. Well, thank you. Before I make this last point, thank you, Sai, for the compliment. We appreciate your support and attention today, as well as everyone's. And we hope that this training was of great value to you. So there's more training available. Guess what? Wednesdays at 2:00. This is your place to be. And we've got a bonus training that's a part of this Road to Recovery 2020 series that, again, is brought to you by the Illinois SBDC at Bill Bronzeville and at Greater Inglewood. So tomorrow, you can join us if you haven't already signed up on eCenter for marketing and branding during this time of disruption. But besides that bonus training tomorrow, everything else that you see listed here, there's additional training coming in June on Wednesdays at 2:00. So be sure that you have secured your spot, you've registered and shared with others you think can benefit from the training that we have today. We're here to serve you, and we look forward to being a great part of your success tools in your small businesses. And if there aren't any other questions, we will say
Will this be
goodbye
on
for the
replay?
day.
Will
Yes,
this
we
be on
will
replay?
send it. Yes, thank you for your question. We will send a recording to you soon, so it will be emailed. Thanks for your question. Okay, everyone, thanks again for your time, your attention, and continue to grow and build your businesses wonderfully. And you know how to contact us for some support. Stay well.
Thank you.